So the chief prosecutor of the ICC, Karim Khan, has urged countries here to find the stamina to deliver international justice. But the real test of that stamina will not be in pledges made at conferences like these, but in countries signed up to the ICC recognizing their obligation to deliver on its orders in the name of international justice.
In a groundbreaking move, the International Criminal Court, ICC, has recently issued an arrest warrant against the President of Russia, Vladimir Putin, raising a host of legal, jurisdictional, and political concerns. Hello everyone, welcome back to Edge Capitalism. Today, we're going to discuss in detail a very sensitive topic of global politics and international law. Are you ready? So let's get started. This video will delve into the reasons why the issuance of such an arrest warrant is not possible within the current international legal framework, as well as explore why this move may be inconvenient in maintaining a balance of jurisdictions and power in the international arena. We'll examine the following critical issues that challenge the legitimacy and enforceability of the arrest warrant. Number 1. Jurisdiction. The lack of ICC jurisdiction over Russia, as it has not ratified the Rome Statute. Number 2. Head of state immunity. The customary international law principle that grants sitting heads of state immunity from prosecution. Number 3. Consent-based system. The voluntary nature of the ICC's jurisdiction, which requires states to agree to be bound by the Rome Statute. Number 4. UN Security Council referral. The influence of Russia as a permanent member of the UN Security Council and its ability to veto any referral to the ICC. Number 5. Complementarity principle. The ICC's role as a court of last resort, which defers to national jurisdictions if they're genuinely investigating and prosecuting the alleged crimes. Number 6. Limited enforcement capabilities. The ICC's reliance on state cooperation for executing arrest warrants and gathering evidence. Number 7. Political considerations. The potential diplomatic and geopolitical repercussions that may arise from pursuing a case against a powerful and influential world leader. Number 8. Precedent. The legal precedents set by previous cases involving sitting heads of state and the unique challenges posed by the Russian president's case. In light of these factors, we will discuss the implications of the ICC's decision to issue an arrest warrant against President Putin, as well as the broader impact on international equilibrium and the balance of power. Also, we will explore how this unprecedented move could potentially strain international relations, disrupt the delicate balance between state sovereignty and international justice, and call into question the effectiveness and legitimacy of the ICC in addressing international crimes. Ultimately, this analysis will offer a comprehensive understanding of the complexities surrounding the ICC's decision and its potential consequences on the global stage. Jurisdiction. The International Criminal Court, ICC, has jurisdiction over only those countries that have ratified the Rome Statute, which is the treaty that established the ICC. Russia has signed but not ratified the Rome Statute, which means the ICC does not have jurisdiction over Russia. So what does this mean? Let's start from the beginning to understand this reason. Jurisdiction refers to the legal authority of a court to hear and determine cases. The jurisdiction of International Criminal Court (ICC) is derived from the Rome Statute, a treaty that was adopted in 1998 and entered into force in 2002. The Rome Statute established the ICC as a permanent international tribunal to prosecute individuals for genocide, crimes against humanity, war crimes, and the crime of aggression. The ICC's jurisdiction is limited to cases involving nationals of states that have ratified the Rome Statute or crimes committed on the territory of these states. A state becomes a party to the Rome Statute by ratifying or acceding to the treaty, thereby accepting the jurisdiction of the ICC over its nationals and territory. Russia signed the Rome Statute on September 13, 2000, but has not ratified it. Signing a treaty indicates the state's intention to consider ratifying it, but does not bind the state to the treaty's provisions. By not ratifying the Rome Statute, Russia has not accepted the jurisdiction of the ICC, making it difficult for the court to exercise authority over Russia's nationals, including its president. The Rome Statute also allows for the possibility of the ICC exercising jurisdiction over crimes committed by nationals of non-party states or on their territory if the United Nations Security Council refers a situation to the court under Chapter 7 of the UN Charter. However, as mentioned earlier, Russia holds a permanent seat on the Security Council and has veto power, making it highly unlikely that it would permit such a referral. Historically, the establishment of the ICC was an attempt to overcome the ad hoc nature of previous international criminal criminal tribunals, such as the International Criminal Tribunal for the former Yugoslavia, ICTY, and the International Criminal Tribunal for Rwanda, ICTR. These tribunals were created in response to specific conflicts and had limited jurisdiction, whereas the ICC was designed as a permanent institution to address international crimes more broadly. Nonetheless, the ICC's jurisdiction remains limited by the principle of state sovereignty and the voluntary nature of its jurisdiction, which requires states to consent to be bound by the Rome Statute. Head of state immunity. According to customary international law, sitting heads of state generally enjoy immunity from prosecution. This immunity applies to foreign courts and international tribunals, making it difficult for the ICC to issue an arrest warrant for the president of Russia. Head of state immunity is a principle of customary international law that grants sitting heads of state, as well as certain other high-ranking government officials, immunity from criminal prosecution in foreign courts and international tribunals. This immunity is based on the legal maxim par imparem non habet imperium, which means an equal has no authority over an equal. The principle is rooted in the notion that the sovereign equality of states should be respected in international relations. Historically, head of state immunity has been recognized to ensure the stability of international relations, protect the dignity of states, and prevent politically motivated prosecutions. This immunity allows heads of states to conduct diplomacy and engage in international affairs without fear of being subject to criminal prosecution in another country's courts or by international tribunals. However, in recent decades, there have been growing calls to limit or eliminate head of state immunity for international crimes such as genocide, war crimes, and crimes against humanity. The establishment of the International Criminal Tribunal for the former Yugoslavia, ICTY, and the International Criminal Tribunal for Rwanda, ICTR, in the 1990s, as well as the adoption of the Rome Statute, signaled a shift towards greater accountability for international crimes, even for sitting heads of state. The ICC has prosecuted sitting heads of state in the past, such as Sudanese President Omar al-Bashir, but these cases remain exceptional. In the context of the President of Russia, head of state immunity would generally protect him from prosecution before the ICC or any other foreign court, so long as he remains in office. However, this immunity would not necessarily protect him from prosecution in domestic courts, which are subject to the laws of his own country. It is important to note that head of state immunity is not absolute, and there are situations in which it may be overridden. For example, if Russia were to ratify the Rome Statute, it would effectively waive the immunity of its head of state for crimes within the jurisdiction of the ICC. Despite the evolving norms of international criminal justice, the principle of head of state immunity remains a significant obstacle to prosecuting sitting heads of states, including the President of Russia, before the ICC or other international tribunals. Consent-based system. The ICC operates on a consent-based system, which means that countries voluntarily submit themselves to the court's jurisdiction. Since Russia has not ratified the Rome Statute, it has not consented to the jurisdiction of the ICC. So let's explain this from the beginning. The consent-based system refers to the principle of international law that states must voluntarily agree to be bound by the rules and obligations of a particular treaty or international institution. In the context of the International Criminal Court, this means that the court's jurisdiction is dependent upon states ratifying or acceding to the Rome Statute, the treaty that establishes the ICC. By ratifying the Rome Statute, a state consents to be bound by its provisions, including accepting the jurisdiction of the ICC over its nationals and territory for crimes enumerated in the statute. This consent-based system is rooted in the principle of state sovereignty, which recognizes that states are the primary actors in international law and that they have the right to determine their own legal obligations. State sovereignty is a cornerstone of the international legal order, as it allows states to maintain control over their internal affairs and protect their interests in the international arena. In relation to the President of Russia, the consent-based system means that the ICC does not have jurisdiction over him unless Russia voluntarily submits to the court's authority by ratifying the Rome Statute. As previously mentioned, Russia has signed but not ratified the Rome Statute, which means it has not consented to the jurisdiction of the ICC. The consent-based system has been criticized for limiting the effectiveness of the ICC in addressing international crimes, as many states have not ratified the Rome Statute, and some states that have ratified the treaty have subsequently withdrawn from it or failed to cooperate with the court. This has led to calls for reforms to the international criminal justice system, including the possibility of creating a more universal jurisdiction for the ICC that would not be solely dependent on state consent. Despite these criticisms and calls for reform, the consent-based system remains a fundamental aspect of the ICC's jurisdiction and the broader international legal order. As long as Russia has not ratified the Rome Statute, the consent-based system will continue to prevent the ICC from exercising jurisdiction over the President of Russia or any other Russian nationals for crimes within the scope of the court's mandate. UN Security Council referral. In some cases, the UN Security Council can refer a situation to the ICC, even if the country in question is not a party to the Rome Statute. However, Russia holds a permanent seat on the UN Security Council, which gives it veto power over any resolutions. It is highly unlikely that Russia would allow such a referral. Now let's explain in more detail. The UN Security Council referral is a mechanism by which the International Criminal Court, ICC, can exercise its jurisdiction over situations involving crimes enumerated in the Rome Statute, even when the state concerned has not ratified the statute or consented to the court's jurisdiction. According to Article 13b of the Rome Statute, the ICC can exercise its jurisdiction if a situation is referred to the court by the United Nations Security Council, acting under Chapter 7 of the United Nations Charter. This referral mechanism allows the Security Council to address situations involving grave international crimes that pose a threat to international peace and security. The UN Security Council is composed of 15 members, including 5 permanent members: China, France, Russia, the United Kingdom, and the United States, and 10 non-permanent members elected for 2-year terms. The permanent members hold the power of veto, which means that if any of them votes against a resolution, the resolution fails to pass, regardless of the number of affirmative votes it receives. In relation to the President of Russia, the UN Security Council referral mechanism is unlikely to be a viable option for bringing him before the ICC. As one of the permanent members of the Security Council, Russia possesses veto power and can block any resolution that seeks to refer a situation involving its nationals or territory to the ICC. This veto power essentially provides Russia with a shield against any UN Security Council referral that could potentially subject its president to the jurisdiction of the ICC. Historically, the UN Security Council referral mechanism has been used sparingly and often faces challenges due to political considerations and the power dynamics within the Council. The Security Council has only referred 2 situations to the ICC thus far. The situation in Darfur, Sudan in 2005, Resolution 1593, and the situation in Libya in 2011, Resolution 1970. In both cases, the referrals faced political obstacles and had limited success in terms of actual prosecutions and convictions. The UN Security Council referral mechanism highlights the tension between the goals of international criminal justice and the political realities of the international system. While the referral mechanism was designed to allow the ICC to address situations of grave international crimes, the power dynamics within the Security Council, particularly the veto power of permanent members, often limit the effectiveness of this mechanism in practice. This constraint is especially relevant in the context of the President of Russia, as Russia's position on the Security Council makes a referral highly unlikely. Complementarity principle. The ICC is designed as a court of last resort, meaning it only steps in when national courts are unwilling or unable to prosecute. If Russia were to investigate and prosecute its president, the ICC would not have the jurisdiction to intervene. So what does it mean for Putin? The complementarity principle is a foundational element of the International Criminal Court (ICC) that governs the relationship between the court and national jurisdictions. According to Article 17 of the Rome Statute, the ICC can only exercise its jurisdiction when national courts are unwilling or unable to genuinely investigate and prosecute the crimes under the court's jurisdictions. In other words, the ICC is intended to act as a court of last resort, stepping in only when national authorities fail to carry out their responsibilities. The complementarity principle is based on the recognition that states have the primary responsibility to investigate and prosecute international crimes committed by their nationals or on their territory. It seeks to strike a balance between the need for international criminal justice and respect for state sovereignty by giving national jurisdictions priority in addressing international crimes. In context of the President of Russia, the complementarity principle means that the ICC would not have jurisdiction over him if Russian authorities were to investigate and prosecute him for alleged international crimes. If Russia were to conduct genuine proceedings, the ICC would be required to defer to the national authorities under the principle of complementarity. However, it is essential to consider that this principle is also subject to the jurisdictional limitations of the ICC. As Russia has not ratified the Rome Statute and has not consented to the ICC's jurisdiction, the complementarity principle would not come into play unless Russia voluntarily submitted itself to the court's authority, or if the situation were referred to the ICC by the UN Security Council, as discussed earlier. Historically, the complementarity principle has been both praised and criticized. Supporters argue that it encourages states to fulfill their responsibility to address international crimes and respects state sovereignty. Critics, on the other hand, argue that the principle can lead to impunity, as states may be unwilling to genuinely investigate and prosecute their own officials, especially higher-ranking ones like heads of states. In summary, the complementarity principle in relation to the President of Russia indicates that the ICC would not have jurisdiction over him if Russian authorities were to genuinely investigate and prosecute him for international crimes. However, this principle is contingent upon the jurisdictional limitations of the ICC and Russia's non-ratification of the Rome Statute. Limited enforcement capabilities. The ICC does not have its own police force or enforcement capabilities. It relies on the cooperation of member states to execute arrest warrants. Without the cooperation of Russia and other countries, it would nearly be impossible for the ICC to enforce an arrest warrant for the Russian president. So how this affects the International Court of Justice in relationship with the President of Russia? The International Criminal Court (ICC) has limited enforcement capabilities, as it does not possess its own police force, all military power to execute arrest warrants, seize suspects, or compel state cooperation. Instead, the ICC relies on the cooperation of states to execute arrest warrants, gather evidence, and provide other necessary support for its investigations and prosecutions. This reliance on state cooperation is a significant constraint on the court's ability to effectively pursue justice in cases involving international crimes. In context of the President of Russia, the limited enforcement capabilities of the ICC would pose a major challenge in executing an arrest warrant, even if one were to be issued. Since Russia has not ratified the Rome Statute, it has no legal obligation to cooperate with the ICC. Furthermore, given Russia's status as a major global power, it is unlikely that other countries would be willing or able to enforce an arrest warrant against the Russian president without Russia's consent. The ICC's limited enforcement capabilities stem from the principles of state sovereignty and consent that underpin the international legal system. The court was established with the understanding that it would operate within the existing framework of international law, which prioritizes the sovereign rights of states. Consequently, the ICC must rely on the voluntary cooperation of states to carry out its mandate, rather than possessing independent enforcement powers. Historically, the ICC has faced challenges in enforcing arrest warrants, particularly for higher-ranking government officials and heads of state. For example, Sudanese President Omar al-Bashir was indicted by the ICC in 2009 and 2010 for genocide, war crimes, and crimes against humanity, but he awaited arrest for nearly a decade before being ousted from power in 2019. Similarly, the ICC has issued arrest warrants for other individuals who remain at large, highlighting the court's enforcement limitations. The limited enforcement capabilities of the ICC in relation to the President of Russia demonstrate the practical challenges facing the court in pursuing justice for international crimes. Without the cooperation of Russia and other states, it would be extremely difficult, if not impossible, for the ICC to enforce an arrest warrant against the Russian president, even if the court were to overcome the other legal and jurisdictional obstacles discussed earlier. Political considerations. International criminal law and the ICC's actions are not immune to political influences. Raising an arrest warrant for the President of Russia could have significant political consequences and could strain relations between Russia and other countries. So what this means in global politics? Political considerations play a significant role in the functioning of the International Criminal Court, ICC, and often impact its ability to pursue justice for international crimes. While the ICC is an independent judicial institution, it operates within the broader context of international relations, where political factors frequently influence the actions of states and international organizations. In the context of the President of Russia, political considerations might hinder efforts to bring him before the ICC. As a major global power, Russia has significant influence on the world stage, including economic, military, and diplomatic leverage. Many countries might be hesitant to support an ICC investigation or prosecution against the Russian president, fearing potential diplomatic repercussions, economic sanctions, or other retaliatory measures from Russia. In this sense, political considerations can limit the ICC's ability to pursue justice against powerful political figures, particularly when their home countries have considerable international influence. Furthermore, political considerations within the United Nations Security Council can also impede the referral of situations to the ICC. As previously discussed, the Security Council has the authority to refer situations to the court under Article 13b of the Rome Statute. However, the Council's 5 permanent members, including Russia, possess veto power, allowing them to block any resolution that deem unfavorable. This means that Russia can effectively prevent the Security Council from referring a situation involving its president or other nationals to the ICC. Historically, political considerations have affected the ICC's work in various ways. For example, the court has faced criticism for being biased against African states, as most of its investigations and prosecutions have focused on situations in Africa. This perceived bias has been attributed in part to political factors, as powerful states outside Africa, such as Russia, China, and the United States, have been able to shield themselves and their allies from ICC scrutiny. Moreover, the ICC has faced difficulties in securing state cooperation and enforcing arrest warrants, often due to political considerations and concerns about the potential consequences of supporting the court's efforts. In summary, political considerations in relation to the President of Russia demonstrate the impact of international politics on the ICC's ability to pursue justice for international crimes. The political influence of Russia, both bilaterally and within the United Nations Security Council, can significantly hinder any efforts to bring the Russian president before the ICC, even if the court were to overcome the other legal and jurisdictional obstacles discussed earlier. And finally, precedent, meaning there is limited precedent for the ICC to issue arrest warrants for sitting heads of states. In previous cases, such as with Sudanese President Omar al-Bashir, the warrant was not enforced, and the defendant remained at large. This precedent may discourage the ICC from pursuing a similar course of action against the President of Russia. This means that precedent in international criminal law refers to the decisions and legal principles established by previous cases, which can serve as persuasive or binding authority for subsequent cases. The concept of precedent, also known as stare decisis in common law systems, is essential for promoting consistency, predictability, and fairness in the application of the law. While the International Criminal Court (ICC) is not a common law court and is not strictly bound by the doctrine of stare decisis, it often relies on precedent from its own cases and those of other international criminal tribunals to guide its decisions. In context of the President of Russia, precedent plays a role in shaping the legal landscape surrounding the prosecution of sitting heads of states for international crimes. Traditionally, heads of state enjoyed immunity from prosecution in foreign courts and international tribunals, based on the customary international law principle of head of state immunity, as explained earlier. However, this principle has evolved over time, with some notable exceptions and developments in international criminal law. The International Criminal Tribunal for the former Yugoslavia (ICTY) and the International Criminal Tribunal for Rwanda (ICTR), established in the 1990s, were significant milestones in this evolution, as they successfully prosecuted higher-ranking officials for international crimes, including heads of states. For example, the ICTY indicted Slobodan Milosevic, the former president of the Federal Republic of Yugoslavia, while the ICTR indicted Jean Kambanda, the former prime minister of Rwanda, both of whom faced charges of genocide, war crimes, and crimes against humanity. The ICC itself has also pursued cases against sitting heads of states, such as the aforementioned case against Sudanese President Omar al-Bashir. These cases demonstrate that the traditional head of state immunity is not absolute and can be overridden in certain circumstances, particularly for international crimes such as genocide, war crimes, and crimes against humanity. In relation to the President of Russia, the precedent of prosecuting sitting heads of states for international crimes may serve as a point of reference, but it is essential to consider the unique legal and political context surrounding each case. As discussed earlier, the ICC faces significant jurisdictional, enforcement, and political obstacles in pursuing a case against the Russian president. The precedent of previous cases involving heads of states does not automatically mean that the ICC can overcome these obstacles or that the traditional head of state immunity may no longer apply to the President of Russia. In summary, precedent in international criminal law, specifically regarding the prosecution of sitting heads of states, is relevant to the context of the President of Russia. However, the unique legal, jurisdictional, and political challenges facing the ICC in pursuing a case against the Russian president mean that the precedent of previous cases alone is unlikely to determine the court's ability to prosecute him for international crimes. In conclusion, the issuance of an arrest warrant by the ICC against the President of Russia, a major nuclear power, not only faces significant legal, jurisdictional, and political obstacles, but also has the potential to undermine the role of the ICC itself and the global balance of power. Pursuing a case against a leader of a powerful nation like Russia could expose the limitations of the ICC's jurisdiction, enforcement capabilities, and the ability to navigate the complex geopolitical landscape. Such a move may strain international relations and cooperation, particularly with states that are skeptical of the ICC's mandate or view the court as infringing of their sovereignty. Furthermore, the potential for diplomatic and geopolitical repercussions arising from the arrest warrant could destabilize the delicate balance of power among nations and trigger unintended consequences that may adversely impact international peace and security. The ICC plays a vital role in promoting accountability and justice for the most heinous international crimes. However, its effectiveness and legitimacy rest on its ability to operate within the boundaries of the international legal system and the realities of the global politics. By pursuing an arrest warrant against the president of Russia, the ICC may risk undermining its credibility and weakening its position in the eyes of the international community.